Good afternoon, I'm Tanya Iser. I'm a senior investigative reporter, joined this afternoon by Juan Sanchez, who is our legal expert for the day. Juan, you and I were talking this while we were having lunch, that from your perspective that it seems like the right thing to do would be to rest.
Yes, I mean, I expect that to happen, actually, especially since they put on their summary witness on right before lunch. That's usually a witness that's called to testify, to summarize all the testimony that you present yourself. And so once they called him, I was like, oh, there's a good chance they could rest. I mean, that could happen. That could happen. I would do that at this point.
You would say, yeah, jury's had enough, and
yes. I mean, it's been a long trial. You made your points that you wanted to during the state's case. You put on a witness that's, gives your point of view as to what an officer would do. So why present any more witnesses? Unless you had something earth-shattering. If it's just somebody who's going to repeat a lot of the things they've already heard, why put the jury through that? And if they're on your side, why alienate them by calling more witnesses?
Right, and for those of you that are just joining us, the person that was on the stand right before we went to lunch was Willie Cantu. He's a retired San Antonio Police Department SWAT officer, and he was testifying about his training and what Adrian Gonzales should and could have done, that kind of thing, and giving his expert opinion on
Correct.
it. That was the gist of it.
Correct.
And then the prosecution had rested this morning around 9:30 or 10, and they had finished up with a witness who was on the stand on Friday, which was kind of a surprise because we really thought the prosecution was going to rest on Friday, and then that didn't happen. So would you expect, let's assume they rest, you mentioned to us that the prosecution can call the rebuttal witnesses. What's the likelihood of that?
I mean, it doesn't happen a lot, but it does happen. I mean, they have the right to call rebuttal witnesses. Once you put on your expert, they can even call their expert back on. I don't think that's going to happen. I'd be surprised if it does, but they have a right to do it, and it happens sometimes. I foresee, if they rest, that the judge could go right into closing arguments today. If they were working hard over the weekend, he might have told both sides, hey, if you think we're going to rest around midday, why don't we go ahead and work on the jury charge? That way, when both sides decide they're not going to call any more witnesses, we can just go ahead and do closing arguments and let the jury give the case to the jury to deliberate.
You think the jury charge has already been done?
I mean, it could be. I mean, a lot. In my experience on big cases like this, most judges will say, why don't we start working on it now? Or sometimes the judge themselves already have one prepared that includes all the issues they think both sides are going to want, and then they'll email it. Even during testimony, you'll get an email from the judge saying, look, this is my proposed jury charge. What do you think? Are there any additions you think we need to make? Is there anything you object to? And usually that's done during the jury charge meeting, and then you put it all on the record to make sure let usually the defense to lodge their objections or what additions they want, and same for the state. And then he'll rule, and he was like, this is what the charge is going to be. Go ahead and do closing arguments. Let's let the jury decide this case.
So if they rest right after lunch, you think we could go straight to closing arguments?
It could happen. It could happen. Now, sometimes the judge hasn't done that ahead of time, hasn't had the jury conference, and he'll say, you know what, both sides have rested, let's send the jury home, we'll have the jury charge, start fresh in the morning with closing arguments, that way the jury has all day to deliberate.
I don't know. It'd be interesting to see, because this judge is definitely motivated to finish that, and he certainly showed that to us this morning.
And they're gauging the jury too. They want, if they're looking tired, he might want to go just straight into closing arguments.
Right, and then just the fact that he, started early at 8:30 this morning, and then he said, "Hey, we're going to go till 5:30." So, and then this morning we had this thing where Nico LaHood was basically telling Nico to wrap it up, and Nico's like, well, I need 7 minutes, which is a very precise number.
Exactly.
And the judge was like, well, wrap it up, and told the witness, if you could answer yes or no, answer yes or no, and if you need to expound upon it, make it short.
Yeah, judge wants to finish this. And of course, we're not privy to a lot of the in-chamber conversations maybe they've had. Judges like to do a lot of scheduling during those in-chamber conversations. Like they'll gauge from the attorneys, like, look, you don't have to tell me what you're doing, but like how many witnesses do you think you're going to call? How about stay? Do you think you're going to call rebuttal? And nobody's ever really committed to the answers they give, but they want to get an idea, like, where are we? You think we're going to finish today? You think we can finish tomorrow? If that's the case, if you think you're going to rest, let's see if we can get the jury charge ready. I mean, that happens a lot, and we, of course, we don't get to see that. But a lot of times I've already told the judge what's going to happen.
Yeah, and we don't know if they've done the jury charge already or not.
Yeah.
You think he would have basically had them do that over the weekend?
I mean, that's usually the way it works. And I don't think there's a lot of complicated issues on this case where you would need a long jury charge or a long meeting or hearing about it.
Really? Why do you say that?
I mean, there's no, like, usually those the jury charges that have complicated issues are like complicated law, or you have defenses that you have to include in the jury charge, like self-defense or justification, things like that. This is just kind of a straightforward jury charge. Like, do you think he acted in a way that put the children in danger under the law or not? I mean, that's really what's going to come down to.
Well, and this is the first time that a police officer has been tried under this statute in this way.
Yeah, it's unique. It's unique. As when I heard about this trial, I had never heard of one like this. I even looked at some research to see if I'd seen one before, and I couldn't find anything.
No, and the only other case similar to it was out in Florida with the police officer who was charged in the Parkland case.
Oh, yes.
He was the sheriff's deputy that was assigned to that school, and he was ultimately found not guilty.
Yeah.
So,
usually the statute is used for caretakers, parents, people who are in charge of taking care of children, like, immediately. That's usually what these statutes are meant for, but I guess they could still use them in situations like this.
what do you make of them having used the statute in this way?
It's very interesting. I mean, I think there was maybe some political pressure in the community to hold somebody accountable for this tragedy, and this is the closest thing they could get.
Well, and what happened here was, I've talked about this, is that what happened here was egregious in terms of the law enforcement response. So there's no way you can defend it.
Yeah, exactly.
And so that's a hard one. There's the former school chief, Pete Arredondo, has also been indicted. But his situation to me is different because he's arriving. He's the chief. He's the incident commander during this long stretch of time when they're trying to decide what to do. And I've listened, and I still struggle with it because I've listened to those body cams, and for the life of me, I'll never understand why they decided that they had a barricaded person on their hands. Like, you listen to them and you just go, okay, guys, you have an active shooter. Why aren't you finish going down the hall and go get him? I don't understand, but for reasons that really don't make any sense to me, you see, and one of the things you do see on the body cam is you see, after other officers arrive, Adrian Gonzales is one of the officers that makes entry into the school with Coronado and Pete Arredondo, and you see Gonzales walk down, with other officers, going down the hallway, and then they come under fire. Do you think that for the jury, the fact that he did make entry into the school ultimately will have some impact?
I think it should have some impact because, again, they're trying to make it sound like he sat in this area for 3 minutes and never did anything, but he did do something eventually. I mean, that's got to count for something. So I think that's going to be impactful, especially when some of the other officers who were there too never did that. So they can argue he did more than a lot of the officers who were at the scene, and I can't believe you're prosecuting him.
Right. Yeah, and some of the stuff that we've seen and heard, it is really hard to understand, and some of this I think is a function of the extraordinary nature of just the way this started, with this crash, and the confusion that surrounded it. But once he gets in the school and once they've realized what they have, that's where I really struggle with, well, there's no good answers for why it took them so long. Do you think, I was kind of asking, like, what else, because some of the other issues that have arisen during this trial is that the exterior door was locked. and the door to 111 was apparently had an issue with it latching properly. And so, but there was a culture at this school where teachers were being given magnets to defeat locks. Now that was not the case on 111. Like I said, there was an issue with it latching. But do you think any of that will play in for the jury?
I mean, I'm not sure if that will. I'm not sure. I think you're just going to look at the defendant and his actions, really, and what. I think the job of the defense is going to have to be to tell the jury the story from his point, from Mr. Gonzales' point of view. They're going to ask him, step into his shoes. Like, what would you, if you were in that position and there was somebody with superior firepower on the other side of that wall, like what steps would you take to protect those children and also protect yourself? I think they're gonna ask him, to put themselves in the position, and they're gonna juxtapose his actions with the actions of the other officers that were there. I think that's the biggest thing they have in the case is, you have all these law enforcement officers who are at the scene, and others take even less action than he did.
Right.
And they were better prepared.
Yeah, and then you also have the issue of that, he also helps rescue some of the children. It's at one point, they start breaking windows and pulling children out. So the idea that he did nothing,
Exactly.
I think, I know what I was going to say.
He didn't run away.
No, he didn't run away. I think the defense's contention throughout this trial has been that he arrives. There's chaos and confusion. He drives up. He encounters Melody Flores. She's frantic, hysterical, all the things, right? Because she has seen this gunman, and she thinks she's been shot, but she's not been shot. I can just imagine what's going on in her mind. And just they're basically saying, look, he's trying to process what's happening. He's hearing gunfire. He doesn't exactly know where it's coming from because he's on the south side. The gunman's gotten onto the west side. And so it seems like the contention is going to be that, the prosecution's trying to say he did nothing, but he did do something.
Exactly.
Maybe you don't like what he did. Maybe you think he should have done more, but is that criminal?
Exactly. And I think that's why they brought that expert witness too, to talk about how you have to assess the situation before you act. You can't just because a witness tells you to run into the school doesn't mean you're going to have to do that. You have to do it the right way. And I think that's how they're going to say if there was 3 minutes of him standing in a certain spot, it's because he was still assessing the situation. You need to figure out where the person was, where the shots were coming from, what's the best way to enter. You can't just run in.
Right. Well, and the other thing that
without having a plan.
Right.
Put it that way.
Well, can we bring up the shot, guys? Because I'm seeing. Here we go. We got audio back in the courtroom.
Please be seated in the courtroom. Defense, you may call your next witness.
Yes, Your Honor. At this time, the defense rests.
Stay in the rebuttal.
We have just a stipulation between the parties. The stipulation is that we have gone back and reviewed, and it was Daniel Coronado who said that at the time Mendoza and Salcedo drove up, it was his voice that was on the radio. And while they had similar voices, he identified that it was his voice on the radio that said, "Shots fired, take cover." So we were stipulating that it was Daniel Coronado, not Adrian Gonzales, who made that dispatch around 11:30, 2:30 mark.
And that was the point of contention, so we agree with that, Judge.
Okay, so it's stipulated, ladies and gentlemen. Members of the jury, as you just heard, both sides have rested and closed the case. That means you've heard all of the evidence in the case. It's now my job, along with the lawyers, to prepare the charge of the court, which you may anticipate will be a fairly lengthy document, and it's going to take a little bit of time to get it ready. So rather than have you waiting around for us to get that document and reading the charge and arguing late in the day, I'm going to excuse you, and we will resume tomorrow with that charge ready to be read, and it'll be immediately followed by the arguments of counsel and then we will ask you to deliberate on the case. So my instructions are still in effect. Please follow them, and we will see you back here tomorrow. Just in case there's anything carrying over on the charge, let's make it 9 o'clock. 9 o'clock tomorrow, we'll see you then. Would everyone rise for the jury?
I almost stood up myself.
Okay, well,
All right. Well, that's what I thought.
you called it.
Yes. If, like I said, if they would have worked on the charge, maybe they still wouldn't have argued today, just because as a defense lawyer, I would be like, I don't want to argue late in the day. Give them 1 hour to deliberate and then go home. You know, I'd rather have them fresh, ready to listen to us, and also give us more time to prepare for closing arguments.
Well,
Yeah.
so if you were constructing, let's kind of do the run through. If you're constructing the defense's closing argument, what are you going to say?
Well, there's a lot. I mean, usually I ask for this trial was how long? 2 weeks? 2.5 weeks?
We had, it's a little over 2 weeks.
So I wonder if he's probably going to give them at least an hour each side, maybe more. Depends. The longer the trial, the more time you get to argue, because there's a lot of things you want to cover. But I going back again, just on what I've seen of the trial so far. Oh.
Okay. Well,
Okay.
we were for a moment there. We
All
were
right.
hearing audio in the courtroom, and so we try really hard not to stomp on audio coming out of the courtroom. So, defense.
I mean, you have to talk about the law. First of all, both sides are going to talk about the law to start with. Usually what they do is they come up and they'll say, "Thank you for your time. You didn't have a choice whether to be here or not. You were ordered to be here as a juror, and you at least when I looked over, you were paying attention. Trying to get some points with the jury, and then go right into the law and how it applies to this case, and talk about how the actions that Mr. Gonzales did take." And try to anticipate, because usually what happens is the state will waive the right to open, because they have a right to open up arguments and close arguments. They can sandwich you in between. Since they have the burden, they have a right to go first and last. But a lot of times what they'll do is they'll waive their right to open, and then the defense gets to go first. And so you want to anticipate whatever arguments they're going to make. So you can say, I anticipate that the state's going to get up here and say this, this, and this.
Right.
And so I want you to remember, though, because I'm not going to be able to get back up here and be able to argue anymore after this. So I want you to remember, when they say this, remember this. Remember, when they say he didn't do anything, remember that he did. Remember that he did eventually go inside. They're going to get you, they're going to try to get you to focus on these, what they say is 3 minutes where he stood in one place. But you heard from our expert. And the expert says it's not that easy. It's not just that he sat there and smoked a cigarette. It's that he was assessing the situation, waiting for backup, trying to figure out where the shooter was and where the shots were coming from. It was an assessment period when he was standing there. It wasn't the fact that he didn't care. And the way you know that he did care was because eventually he did go inside. He did act in a way to protect those children, and present the case that way from his point of view, and also talk about the fact that he was charged when many other people could have been charged too that did much less than him, and they're just trying to make him the scapegoat for a terrible event that happened. And it's not right that this one man be criminally charged and his liberties put at stake when he did more than a lot of the other law enforcement officers that showed up to the scene.
And if you're the prosecution?
Prosecutors are going to say they're going to harp on his duty. They're going to build up law enforcement and the power that they have to stop these kinds of tragedies. They're going to say, he's a sworn peace officer. He knew what kind of job he was getting into. This is what he received training for, and this was the time that he was supposed to show his training and protect the people that he swore he was going to do, and he failed. And because he failed to act, look at the destruction that happened. We're not saying that he's responsible for it, but he could have mitigated it. He may have been able to stop it, and he didn't do it. And that's all we're asking you to do, is to hold him accountable for what he didn't do.
Well, it'll be very interesting to see how it turns out, and certainly it gives us some indication well, we've gotten the, in some ways, we'll see what happens when Pete Arredondo goes on trial next.
Oh, yeah.
So, okay, folks. Well, thank you for joining. Again, thank you, Juan
Short day.
Sanchez, for joining us today. Well, you know, and this whole trial has been difficult to assess, like how long they were going to go. At one point, we were hearing the defense might go a day and a half, and obviously that did not happen. But we will be back tomorrow at 8:30 a.m. and you know we'll be waiting to see what what the jury charge looks like and what what they say in their we've heard what what you think is going to be in there. And so if you guys want to go back and watch any of the proceedings or analysis, you can go to our YouTube page. You can go to our Plus page. And anyway, thank you for joining us, and we'll see you tomorrow at about 8:30 a.m.